want to put.
I was going to say, you make me nervous when you approach the podium. How you doing? Good. Go ahead.
I just wanted to once again reiterate our objections
To the jury instructions.
To the jury instructions that we stated yesterday.
Okay.
And Mr. Fernandez and I worked feverishly last night and this morning to make sure that it was in proper form.
And I truly appreciate the hard work. A lot of people don't know what goes on behind the scenes. While everybody goes home and sleep, the lawyers are working really hard. So I appreciate it, guys, and it looks like I have a clean set right here ready to work off of.
Yes, sir.
All right. Let's bring in the jury. Jury Endangerment. Good morning, guys.
Good morning. Good morning.
How are you?
Good morning.
Good morning. Thank you. Good to see you. Thanks. Good morning, sir. I took the liberty and left those jury instructions. I promise you. Everybody else have a seat. Good morning to everybody in the courtroom. All right, to my jurors, how are you? Everything's okay? No issues last night? Anything that I need to be informed about? Nothing at all. Everybody's good. We're ready to get working. Now, I told you, let me give you a little lay of the land. This is the way I see it. You know, obviously within a few minutes on each side of it. We said we'd start at 8. We're almost right on the button. And thank you for being so early. I know that's difficult. So what's going to happen is I'm going to read these instructions so you remember I have to read them to you. When I'm done reading, Ms. Ellis for the state's going to stand up and give her first part of her closing. When she's done, we're going to take about a 5-minute break. Let the attorneys swap out, get things set up the way they want it, and we're going to have menus for you to order, all 10 of you. Okay, so order your food. When you come back in, Mr. Lubin for the defense is going to go for 2 hours. We'll take another 5-minute break so everybody just swaps and gets comfortable, and then the state's going to have final words. Then I'll have a last couple of instructions for you. Then the 6 folks who are actually going to serve as jurors in the case are going to go back, have their lunch hopefully there. I suspect it'll be around 12:30, so hang in there with me. We got some snacks back there for you. Feel free to bring them to your seat. Because I suspect it'll be around 12:30. And at that juncture, I'll get the 6 in, get the 4 their lunch. I'll talk to you all separately. So with that being said, if you look at your packet, the first 5 pages I've already read to you. So I want you to flip past those. I promised you I'd give them to you, but there's no need for me to read them again. So at the top of the page that I want to start on, and each of you, I want you to follow along with me because it's imperative that you have exactly what I'm reading to you. And if you don't, but sometimes the copy machine eats a page, whatever, I need you to raise your hand and we need to know about it because we'll get you a copy. So everybody should start with Introduction to Final Instructions. Is everybody there? I think it's page 6. They're not numbered, but I think it's page 6. So here we go. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Nouman Raja, the defendant in this case, has been accused of the following crimes. 1, manslaughter while armed. 2, attempted first-degree murder with a firearm. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of manslaughter while armed are 1, manslaughter, 2, culpable negligence. The lesser crimes indicated in the definition of attempted first-degree murder with a firearm are attempted second-degree murder with a firearm, 2, aggravated assault with a firearm, and 3, assault. In this case, Nouman Raja is accused of manslaughter while armed and attempted first-degree murder with a firearm. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Corey Jones was killed by Nouman Raja, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or whether the killing was excusable or resulted from justifiable use of deadly force. The killing or attempted killing of a human being is justifiable homicide and lawful, if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing or attempted killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing or attempted killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing or attempted killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing or attempted killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. It is a defense to the crimes of manslaughter while armed and attempted first-degree murder with a firearm, including lesser-included offenses, if the actions of Nouman Raja constituted the justifiable use of deadly force. Deadly force means the force likely to cause death or great bodily harm. The use of deadly force is justifiable if Nouman Raja reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting another's attempt to murder him or any attempt to commit aggravated assault upon him. Nouman Raja was justified in using or threatening to use deadly force if he reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to himself or the imminent commission of murder or aggravated assault against himself. Attempted murder will be separately defined. The elements of aggravated assault are as follows. 1, Corey Jones intentionally and unlawfully threatened, either by word or act, to do violence to Nouman Raja. At the time, Corey Jones appeared to have the ability to carry out the threat. 3, the act of Corey Jones created in the mind of Nouman Raja a well-founded fear that the violence was about to take place. And 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Nouman Raja may be found to have been in fear, and actual fear on the part of Nouman Raja need not be shown. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. If Nouman Raja was not otherwise engaged in criminal activity and was in a place he had a right to be, then he had no duty to retreat and had the right to stand his ground. In deciding whether Nouman Raja was justified in the use or threatened use of deadly force, you must consider the circumstances by which he was surrounded at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force or threat of force. Based upon appearances, Nouman Raja must have actually believed that the danger was real. However, Nouman Raja had no duty to retreat if he was not otherwise engaged in criminal activity and was in a place where he had a right to be. However, the use or threatened use of deadly force is not justified if you find that Nouman Raja used force or threat of force to initially provoke the use of threatened use of force against himself, unless the threat of force asserted toward the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on Corey Jones, or, in good faith, Nouman Raja withdrew from physical contact with Corey Jones and clearly indicated to Corey Jones that he wanted to withdraw and stop the use or threatened use of deadly force, but Corey Jones continued to resume the threatened use of force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Nouman Raja and Corey Jones. If in your consideration of the issue of self-defense you have a reasonable doubt on the question of whether Nouman Raja was justified in the use of deadly force, you should find him not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Nouman Raja was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proved. I now instruct you on the circumstances that must be proved while Nouman Raja may be found guilty of manslaughter by armed and attempted first-degree murder with a firearm or any lesser-included crime. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. One, Corey Jones is dead, and two, the death of Corey Jones was caused by the culpable negligence of Nouman Raja. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty by manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I've previously instructed you. I will now define culpable negligence for you. As I've said, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness or grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. If you find Nouman Raja guilty of manslaughter, you must also determine if the state has proved beyond a reasonable doubt whether, in the course of committing the manslaughter, Nouman Raja was armed with a firearm. A firearm means any weapon which is designed to or may be readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find Nouman Raja carried a firearm in the course of committing manslaughter, you should find him guilty of manslaughter while armed with a firearm. To prove the crime of culpable negligence as a lesser-included offense to count one, the state must prove the following two elements beyond a reasonable doubt. Nouman Raja exposed Corey Jones to personal injury, inflicted actual, or, it should be an or there, right, guys? Yes. There should be an or there. Take your pens and just put an or between A and B, or inflicted actual personal injury on Corey Jones. And number two, Nouman Raja did so through culpable negligence. I will now define culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard of the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of attempted first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. One, Nouman Raja did some act intended to cause the death of Corey Jones that went beyond just thinking or talking about it. Number two, Nouman Raja acted with premeditated design to kill Corey Jones. And three, the act would have resulted in the death of Corey Jones except that someone prevented Nouman Raja from killing Corey Jones or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. If you find Nouman Raja guilty of attempted first-degree murder, you must also determine if the state's proved beyond a reasonable doubt whether, in the course of committing the attempted first-degree murder, Nouman Raja was armed with a firearm. A firearm means any weapon which is designed to or may be readily converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find Nouman Raja carried a firearm in the course of committing attempted first-degree murder, you should find him guilty of attempted first-degree murder with a firearm. Now, attempted second-degree murder. To prove the crime of attempted second-degree murder is a lesser-included offense as to count 2, the state must prove the following 2 elements beyond a reasonable doubt. 1, Nouman Raja intentionally committed an act which would have resulted in the death of Corey Jones, except that someone prevented Nouman Raja from killing Corey Jones or he failed to do so. 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict a defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find Nouman Raja guilty of attempted second-degree murder, you must also determine if the state's proved beyond a reasonable doubt whether, in the course of committing the attempted second-degree murder, Nouman Raja was armed with a firearm. I know I've told you this before, but I got to read it again. A firearm means any weapon which is designed to or may be readily converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find Nouman Raja carried a firearm in the course of committing attempted second-degree murder, you should find him guilty of attempted second-degree murder with a firearm. Aggravated assault. To prove the crime of aggravated assault as a lesser-included offense to count 2, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. 1, Nouman Raja intentionally and unlawfully threatened, either by word or act, to do violence to Corey Jones. 2, at the time Nouman Raja appeared to have the ability to carry out the threat. 3, the act of Nouman Raja created in the mind of Corey Jones a well-founded fear that the violence was about to take place. And 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Corey Jones may be found to have been in fear, and actual fear on the part of Corey Jones need not be shown. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. A firearm means any weapon which is designed to or may be readily converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find Nouman Raja carried a firearm in the course of committing aggravated assault, you should find him guilty of aggravated assault with a firearm. To prove the crime of assault as a lesser-included offense as to count 2, the state must prove the following 3 elements beyond a reasonable doubt. 1, Nouman Raja intentionally and unlawfully threatened, either by word or act, to do violence to Corey Jones. 2, at the time Nouman Raja appeared to have the ability to carry out the threat. And 3, the act of Nouman Raja created in the mind of Corey Jones a well-founded fear that the violence was about to take place. The defendant has entered a plea of not guilty, and this means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or to prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Now, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness' testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses is it called or upon the number of exhibits it has offered, but instead upon the nature and the quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Now, you heard some transcripts here. You've seen the transcripts. You have heard recorded conversations. These recorded conversations are proper evidence, and you may consider them just as any other evidence. You are also being furnished transcripts of the recorded conversations. The recordings are the evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recordings. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recordings and what you read in the transcripts, you must rely on what you hear, not on what you read. The Constitution requires a state to prove its accusations against the defendant. It's not necessary for the defendant to disprove anything, nor is a defendant required to prove his innocence. It's up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case, and you must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Now, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the laws as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses, that you've seen in the form of the exhibits and evidence, and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or you're angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It's my job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render, it must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Now, deciding a verdict is exclusively your job, and I cannot participate in that decision in any way. And please disregard anything I may have said or done that makes you think I prefer one verdict over another. The next page you have is verdict. So what I'm going to do is stop right there. When the lawyers are done presenting their closing arguments, I'll read the last 4 or 5 instructions. I'll also go over the verdict form with you. I got a feeling the lawyers are going to do that as well, but I'll do it at the very end. So, State, you ready?
Yes, Your Honor.
You may proceed.